Hello, and we're back talking about free speech. In this case, in this lecture, we're going to talk about permissible regulation of speech by government. And this follows what turned out to be a rather long introduction to the concept of free speech and Supreme Court rules and concepts for evaluating government regulation of speech. I'll try and break this up a little bit and keep it a little bit shorter for us. So here's a list of things we're going to cover and things we'd like to, we think of in terms of regulation of speech. Symbolic speech is expression that is nonverbal, doesn't involve actual speech. It can also be mixed. Symbolic speech can be mixed with free speech. So someone is speaking while engaging in a symbolic act or holding up signs or protesting in forms that don't involve actual speech. Also, we need to talk a little bit about public forums, what those are and how government can regulate them. Hate speech, a right not to speak, and commercial speech and freedom of association. Okay, so symbolic speech involves, like I said, things like picketing or even so far as to go to make a symbolic act that is designed to point up one's opposition to a government policy. In one case, for example, uh, uh, potential draftees burned their draft cards during the Vietnam War. Other forms of symbolic speech also involve flag burning or holding up signs and things like that. And the court said in 1940 that these types of speech, things that are not pure speech, still receive some level of protection under the First Amendment. However, the court went on the next year to say that regulation of these sorts of things is okay, is permissible governmental regulation, because government has an interest in preventing violence and ensuring that that there is order at the site of public protests. So why are these cases so difficult? Well, the real problem is that they are mixed with speech and non-speech, and the First Amendment doesn't directly address nonverbal or symbolic speech. And another reason why they're so difficult is that as we said before, there's a distinction between public speech and private speech, and most of our cases will deal with people speaking in public on matters of public importance. United States versus O'Brien, another case, very important. I think I already mentioned it, involved the burning of draft cards. The court was unwilling to protect that act for two reasons. So O'Brien was punished actually for burning his draft card. The first reason was that the draft card was the property of the United States, and so what O'Brien was actually doing was destroying governmental property, and government has an interest in ensuring that its property remains intact, and that extends to things like government issued identification, in this case draft cards. But O'Brien claimed that all he was doing really was protesting in a symbolic way the Selective Service Act that required him to register for the draft and perhaps go to Vietnam. The court also said that other avenues were open to O'Brien to protest the draft. He didn't all other avenues were not forestalled for him to express his displeasure. He could have expressed his displeasure with the Selective Service Act in any other of a variety of ways and still gotten his message across. Uh, so the court has, even when dealing with symbolic speech, the court has used the preferred freedoms doctrine. In this case, Street versus New York, no majority emerged. The rule generally is that symbolic speech receives some protection under the First Amendment, but that protection is not as great as pure speech. So, for example, as in the O'Brien case, the United States could place an a priori restraint on the destruction of the Selective Service identification card and say, if you burn it, we're going to punish you. And that would be acceptable under the First Amendment. So there's another important case that this one, Spence versus Washington, references here, and that involves the Tinker versus Des Moines, Iowa. You should look at that case in our textbook. The Tinker children came to school with black armbands on. They had been told specifically by the principal of the school that no protest of the Vietnam draft would be, the Vietnam War would be allowed, and even symbolic forms of speech. And they went ahead and wore black armbands. There was no evidence whatsoever that wearing the black armbands disrupted the educational environment, which is the reason why the school district said that no students could engage even in that form of protest. And in finding for the Tinkers in this case and against the school district, the Supreme Court said in its majority opinion a very famous phrase that students do not check their free speech rights at the schoolhouse gate. And so the policy of forestalling any form of protest actually was too broad and stopped too much speech. In Spence versus Washington, the court equated the speech in public with that sort of nonviolent expression that the Tinkers engaged in. And then, of course, we have Texas v. Johnson, which involves burning the American flag. And the court stated that in siding with Johnson over Texas, they said that the free speech right requires the ability of individuals to express their concerns with government, even to the extent of burning the flag, and that the state's interest in preserving the public order was not as great as the right of the individual to symbolically protest. Texas argued that burning the flag would incite violence among those who viewed it, and the court did not buy that argument. That is a very difficult issue. Personally, I think that we have other methods of expressing our displeasure, and burning the flag is not necessarily something, it's an immoderate act. It's not necessarily something that we absolutely have to have in order to express our opinion on matters of public importance. And I don't really understand why we can't protect a sacred symbol of the nation, and why we have to give people the opportunity to do that. I don't think we're forestalling other forms of protest by saying that we shouldn't be burning the flag. Okay, the importance here, though, in terms of symbolic speech, is that the potential for violence is the key for determining whether government can regulate it. All right, we talked a little bit about Texas v. Johnson. The question there was, does a state law that prohibits the burning of the American flag violate the First Amendment freedom of expression? The court says, yes, it does. Closely divided court. Brennan says, the bedrock principle underlying the First Amendment is that government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. I agree with that statement. I am not certain, though, that it's definitive in deciding this case, because there are all sorts of other methods for people to express their distaste for governmental policies other than burning the flag. So we move on to talk about pure speech in public forums. So now we're back to talking about actual expression, not just symbolic speech. So I've mentioned this several times, that public speech is different from private speech or speech in what is called a limited forum. So first, let's define what a forum is. A forum is a place established by the state so that the public can express itself. There are things called traditional public forums. These traditional public forums are places where people have traditionally gone and we have a historical commitment to people accessing them. They include streets and sidewalks and public places like that. There are also like parks and things. There are also other kinds of forums, limited forums where that government has set up for an explicit purpose. For example, uh, a place of education like a primary, secondary school or a university is set up so for the discussion of particular topics, and these are limited in terms of who can access them. So to get into my class, you have to actually be enrolled in my class. This is not open to the public generally. There are also other types of forums that are set up for the explicit purpose of discussing a particular topic. So we might reserve a large hall at a university for a public presentation for the discussion of a particular topic. Say we might be discussing something like flag burning or Black Lives Matter or some other topic like that. And if someone enters that forum and attempts to discuss some other topic like abortion, the state is justified in expelling that person from the forum because that limited forum was set up for a short period of time for the explicit purpose of discussing that topic. Now, of course, the state, if let's say the state sets up a forum for the discussion of flag burning, it can't then expel people from that forum because they take a particular position about flag burning. That would be called viewpoint discrimination. So the answer to why is public speech different from private speech or speech in a limited forum, like we've just defined, is that speech has the potential to threaten order and create violence, and the state has an interest in preventing that, which must be balanced against the exercise of the right. So the key in all of these cases we've been discussing is to look at the effect of the speech, on the public, the potential for violence. But then we have to define what is potential for violence, because every speech is an incitement, right? Every idea is an incitement. So we have to look at the probability that speech will cause violence and what steps government could take to avoid violence while allowing speakers to continue to speak. All right, one of the cases that has importance for understanding some bedrock principles for how government may restrict speech is Chaplinsky versus New Hampshire. This was a case involving a Jehovah's Witness who was out proselytizing and handing out leaflets and playing records in public, and a crowd gathered, and they were attempting to, it looked like violence might break out. Chaplinsky was saying certain things, including some very anti-Catholic rhetoric, and it looked like the crowd might get violent. The police intervened. They actually arrested Chaplinsky in order to protect him from the violence of the crowd. And Chaplinsky's actions at that point changed this case from being a religion case, a free exercise case, to a speech case, because he said certain things to that officer. He called him a fascist and a goddamn racketeer, and he was arrested for that speech. So the question is, does a state law that prohibits the use of offensive words to someone on the street violate the First Amendment right to freedom of speech? And the answer was no, a unanimous decision. The court says that it was unable to say that the limited nature of the statute contravenes the constitutional right to free speech. So the statute was narrowly drawn to restrict only a specific type of words that had a history and tradition of leading to violence, and it was designed to punish specific content and conduct in a public place that was likely to cause the breach of the peace. Okay, so there's a couple other cases involving the application of the fighting words doctrine in public forums. In Terminello versus Chicago, the city attempted to punish someone or to keep them from speaking because they said that there was a possibility, however remote, that violence might occur. Remember, there's a possibility, however remote, that violence might occur whenever anyone opens their mouth. And the court ruled in favor of Terminello and said speech is protected unless there is a clear and present danger that's presented by the speech. In Feiner, the court said that speech that tends to incite violence may be stopped. So, clearly, if there is a history of certain types of speech creating violence, the state may stop the speech. And both of these cases lead to a symbolic speech case called Cohen versus California. This case is often referred to by the language that was spray painted on the back of a leather jacket that Cohen wore into the county courthouse in Los Angeles. And so it gives me an opportunity to say a word that some people might find offensive, but we're all adults here, so this is often referred to as the fuck the draft case. Now, someone had spray painted fuck the draft on the back of Cohen's leather jacket. He wore it into the county courthouse, and it was unrelated to the business that he was doing in the courthouse. A police officer saw the words, noted that there were women and children present, and arrested him for breach of the peace. And the court said that the state has no business in restraining symbolic speech of that nature simply because they anticipate that some people might be offended by it. Okay, general public forum issues. So a general public forum is one that the state has created not for a specific purpose, but for generally it is there for people to gather and to discuss whatever topic and to communicate their position to government. And in Edwards versus South Carolina, the Supreme Court says that if you're in one of those forums and you're protesting non-violently, you are protected from, and the speech is protected from regulation by government. In Cox, the court makes it very clear that violence, the potential for violence, and actual violence is the key here. But even in such a situation, the state has an interest in this case it was protecting the judicial system, but the state has an interest in ensuring the proper and smooth function of government. So if someone is protesting non-violently and disrupting a courtroom, disrupting the conducting of business of the state, the government has a right, has the power to expel that person, possibly punish them. In Adderley, the court affirmed the idea that reasonable regulations of time, place, and manner are perfectly fine, are constitutional restrictions on speech. The state has an interest in maintaining orderly conduct and requiring people to fill out a registration form and to designate where and when and how they will be protesting is a permissible constitutional regulation. However, using those things to ensure that someone cannot access a forum, abusing time, place, and manner restrictions is not permissible. And then finally, in this case, the state can regulate the time of protests. Once again, though, the state cannot use time and also place to ensure that no one hears the message of the protesters. Okay, well, thank you very much for your attention, and we'll move along.